Welcome to the Deep Dive. Today we're tackling a Supreme Court case that, on the surface, sounds like it's all about dry legal procedure.
Yeah.
This concept of standing.
But it's really not. It's actually a story about a desperate, high-stakes fight for evidence that could mean the difference between life and death for an inmate on death row.
Exactly. We're doing a deep dive into Gutierrez v. Saenz, a case the Supreme Court decided this past June. And our mission today is to unpack how these really complex ideas, standing, due process, how they crash into the world of post-conviction DNA evidence.
And we're using the real-world case of Ruben Gutierrez, a Texas prisoner, to see how it all plays out.
So when you hear a term like standing, you might think, where are you standing? But in federal court, it's something totally different. It's like the court's bouncer.
Right. It's the legal gatekeeper. The first question is always, does this person even have the right to be here in federal court bringing this specific lawsuit?
And in this case, Gutierrez is trying to challenge this Texas law, Article 64, which he says is basically locking away DNA evidence that could, well, potentially save his life.
It's a huge barrier.
Before we get into all the legal back and forth, let's just quickly set the scene. I mean, this all started with a terrible crime.
It did. The story begins way back in 1998 in Brownsville, Texas. An 85-year-old woman, Escholastica Harrison, was murdered in her mobile home.
A really brutal crime, I understand.
Horrific. She was stabbed 13 times with 2 different screwdrivers during a robbery.
And the state's case against Ruben Gutierrez, it relied pretty heavily on his own words, didn't it?
It did, yes. The prosecution's key piece of evidence was Gutierrez's own signed confession. He admitted that he and 2 accomplices planned to rob her.
Okay.
And crucially, that confession said he went inside the home, he took money, while one of his accomplices did the stabbing.
But Gutierrez later took that back. He said the confession was forced and that his story was completely different.
Completely different. He claims he never set foot inside that mobile home. And that claim, that one detail, is the hinge that this entire 2-decade-long legal battle turns on.
So why is that so important? This is where we get into a really key piece of Texas law, right? The law of parties.
Exactly. We have to understand this to get the rest of the case.
So break it down for us. What does the law of parties mean for someone like Gutierrez?
It basically means that if you're part of a felony, like a robbery, and someone ends up dead during that robbery, you can be found guilty of capital murder.
Even if you weren't the one who actually, did the killing.
Precisely. You were a party to the crime that led to the death. So in the eyes of the law, you're just as responsible for the murder.
Okay, so under that law, he's guilty of capital murder because he helped plan the robbery. If that's settled, why on earth does it matter if he was inside the house or not? Why is he still fighting this?
Because that is the critical distinction. It's not about his guilt for the crime. It's about his eligibility for the sentence.
The death penalty.
The death penalty. For a jury in Texas to sentence someone to death, they have to clear a much, much higher bar.
Okay, what is that bar?
The jury has to find that he either actually caused the death or that he intended to kill her, or, and this is the part that matters for Gutierrez, that he anticipated that a human life would be taken.
I see it now. So his argument is, if my DNA is nowhere inside that home, it proves I was outside.
Right.
And if he was outside, it makes it a lot harder to argue he anticipated that this robbery would turn into a murder.
Exactly. It casts serious doubt on that one specific finding the jury had to make to give him the death penalty. He isn't trying to overturn his murder conviction. He's trying to get off death row.
So what specific evidence has he been trying to get tested all these years?
Well, since 2010, his lawyers have been asking for testing on key items from the scene. Things like scrapings from under Mrs. Harrison's fingernails, a loose hair found at the scene, blood samples.
And if his DNA isn't on any of that, his case gets a lot stronger.
Dramatically stronger. But Texas put up a massive legal wall. It's called Article 64.
And this is their law that governs post-conviction DNA testing.
Yes, and it sets an unbelievably high bar. The law says the convicted person has to prove by a preponderance of the evidence, so more likely than not,
Okay.
that he would not have been convicted if exculpatory results had been obtained.
Wait, that sounds like a complete catch-22. You have to prove what the test will show before you're even allowed to do the test.
It feels that way.
Yeah.
And the Texas Court of Criminal Appeals, or the TCCA, they agreed with the state. They shot down his requests, first in 2011 and then again in 2020.
And they had specific reasons for saying no.
They had two main reasons, and they're both really important. First, they said Article 64 is really designed to prove actual innocence of the crime itself.
Not just to challenge the sentence.
Right. They basically said, look, you confessed to the robbery, so you're not claiming you're totally innocent, so no test for you.
And what was the second reason?
The second reason is what becomes this huge problem later on. The TCCA also said that, look, even if we ignored that first part, we've reviewed the trial record, and we believe it already shows you played a major role and showed a reckless indifference to human life. So in their view, even if the DNA test came back clean, it wouldn't be enough to change his death sentence anyway.
So with every single door in the Texas state court system slammed shut, his lawyers had to find another way in.
And that's when they pivot. They take the fight to federal court, which is what brings us to the Supreme Court.
This is where things get really interesting. He files a federal civil rights lawsuit against the district attorney, Louis Saenz.
Right, because Saenz is the one who physically has custody of the evidence, and Gutierrez isn't asking the federal judge, hey, order the DNA test. He's making a more clever argument.
What's the argument?
He's saying that the Texas procedure, the whole Article 64 setup, is unconstitutional, that it violates his liberty interests under the Due Process Clause.
So the logic is, Texas gives me a right to challenge my sentence. It's called a habeas petition. But then it makes the very evidence I need to win that challenge impossible to get.
You've got it. It's like giving someone a key to a car but refusing to tell them where the car is parked. The right becomes an illusion.
And the first federal court, the district court, they bought that argument.
They did. They issued what's called a declaratory judgment, saying it was fundamentally unfair and that the state's habeas right had become illusory.
But then it goes up to the next level, the Fifth Circuit Court of Appeals, and they reverse it. They bring it right back to that issue from the beginning, standing.
Yes, the Fifth Circuit zeroed in on one specific part of standing called redressability.
Okay, in plain English, what is redressability?
It means if we, the court, rule in your favor, is it substantially likely that your injury will actually be fixed? Will our ruling actually solve your problem?
And the Fifth Circuit said no.
They said no. They basically said, look, even if we give you this piece of paper, this declaratory judgment saying the law is unfair, we don't think it will actually cause the prosecutor to hand over the DNA.
Why not?
Because of those other reasons the Texas court gave. The TCCA had multiple independent state law reasons for denying the test. So the Fifth Circuit thought a federal ruling on just one of those reasons would be pointless.
So they were demanding a guarantee of the final outcome, not just the chance to fight the procedure. That feels like an impossibly high bar.
It is an incredibly high bar, and that's why the Supreme Court stepped in. They had actually dealt with a very similar Texas DNA case just 2 years earlier, Reed v. Goertz.
So everyone was waiting to see how they'd apply that precedent here. Let's get to the decision. What did the majority, in the opinion written by Justice Sotomayor, decide?
The majority came down firmly on Gutierrez's side. They said he does have standing. And their main point was that the Fifth Circuit was asking the wrong question entirely.
How so?
They said the lower court was wrong to require a guess about whether the prosecutor would ultimately turn over the evidence. You can't demand that level of certainty for a procedural claim.
So if the problem isn't whether he'll get the evidence in the end, what is the problem, according to the Supreme Court?
The problem, the injury, in legal terms, is being denied access to the evidence because of an unconstitutional reason. The injury is the illegal barrier itself.
The barrier is Article 64's narrow scope.
Precisely. So a federal court order that strikes down that specific legal justification, well, that fixes the injury. It removes the prosecutor's ability to hide behind that specific unconstitutional reason.
So the goal is just to knock down the wall. You don't have to prove what you're going to find on the other side.
That's the perfect way to put it. Removing that one specific barrier is enough to give him standing to be in court. The court's job is to clear the illegal roadblock, not guarantee what happens down the road.
Now, the DA, Saenz, he tried another argument, didn't he? Something about the case being moot.
He did. He argued that since he still refused to allow testing, even after that first federal court ruling, the whole issue was moot. Basically pointless.
How did the court handle that?
They shut it down immediately. Sotomayor wrote that you can't allow a state official to manufacture mootness just by digging in his heels and refusing to comply. That would make a mockery of the whole system.
Of course. Otherwise, any state could just ignore a federal court ruling and claim the case is over.
It would make procedural challenges completely toothless. But, while the majority's logic seems pretty clear, this was a 5-4 decision. It was very close. And the dissents show a deep, deep disagreement on the court.
Let's start with Justice Alito's dissent. It seems like he was siding with the original Fifth Circuit view.
He was, very strongly. Alito basically accused the majority of twisting that earlier Reed precedent to get the result they wanted. He went right back to those independent state law barriers.
The TCCA's other reasons for saying no.
Exactly. He pointed out that the Texas court had also said Gutierrez showed reckless indifference, and that his motion was just a delay tactic. Those reasons were never challenged in federal court.
So Alito's point is, even if you knock down the Article 64 wall, these other two walls are still standing, so the testing is still not going to happen.
That's his argument. He believed the injury was therefore not substantially likely to be redressed. It's a fundamental disagreement. The majority says, did we remove an illegal barrier? And Alito is asking, did we remove all the barriers?
A huge difference. But Justice Thomas, in his dissent, he went even further. He questioned the whole premise of a case like this being in federal court at all.
He did. Thomas raises a truly foundational debate about the 14th Amendment itself. He argues that the Due Process Clause is really only there to protect natural rights.
What does he mean by natural rights?
Things like life, liberty from physical restraint, property, rights that exist on their own, separate from any government action.
And he's saying that a procedure for post-conviction DNA testing is not one of those.
Exactly. In his view, Article 64 is a procedure that the state of Texas voluntarily chose to create. It's not a natural right. And if the state creates a right, he argues, the state also gets to create the limits on that right, and the federal courts should stay out of it.
Wow. That is a legal philosophy that would completely reshape the relationship between federal and state courts in criminal justice.
It would be a radical shift.
Yeah.
Thomas's big concern is about delay. He writes that these kinds of federal lawsuits just add to the egregious delays endemic to capital litigation and become a tool for obstruction.
So you have this incredible tension between, on one side, ensuring every procedure is fair no matter how long it takes.
And on the other side, a desire for finality and an end to these decades-long appeals. This case is a perfect snapshot of that conflict.
So if we're trying to boil this all down, what's the key takeaway for someone trying to understand what this case means?
The single biggest takeaway is that the Supreme Court has affirmed a prisoner's procedural right to challenge the rules that block access to evidence. It's a win for the right to fight the process, but it's not a guarantee that you'll win the right to the evidence.
And it really shines a light on that huge difference in capital cases between proving you're innocent of the crime itself versus just proving you're ineligible for the death sentence.
It absolutely does. And it shows that the federal courts are, for now, still willing to act as a check on state procedures to make sure that a right, once granted by a state, isn't just an empty promise.
Which leaves us with a really provocative question to think about. If a state decides to grant a right, like the right to challenge a death sentence, does the Constitution's Due Process Clause then require the state to also provide the tools like DNA testing to make that right meaningful?
Even if the state legislature never intended for it to be that broad, this ruling suggests that yes, procedural fairness is paramount. You can't give someone a map, but then refuse to give him the keys to the car.
A really critical deep dive into the nuts and bolts of how justice is fought over at the highest levels. Thank you for walking us through that.
My pleasure.